Hi everyone, I'm Catherine and I'm here to take you from academic legal English to the real legal English you need to work in law. Download your free PDF today. It's a vocabulary book with sentences and most importantly, an answer key. Welcome to our quick legal English vocabulary class. Consideration. Under the English common law, there are 4 essential elements that are necessary to form a legally binding contract. The 4 elements of a contract are offer, acceptance, consideration, and intention to create a legal relationship. Our courts say if you have 2 parties who are arguing about whether a contract exists or not, this is the criteria that you apply. If all 4 are present, you've got a contract. But if just one of them is missing, you haven't. And today we're going to talk about number 3, consideration. What is consideration? In contract law, the academic definition is that consideration is the absolutely essential thing which is exchanged between the parties. When each party gives the other something or loses something, this is what creates a legally binding agreement. Now, if you come from a codified legal system, this might be very different. I'm not sure if you have this element of consideration as being absolutely necessary. But it basically just means something has to travel in each direction. You give something or you lose something. The promise of a gift isn't a contract. One of the parties gave nothing in return. That's what consideration is. It's what you give or what you lose. Some examples now of what our courts have decided is good consideration under a contract. Money, goods, a promise to do something in future, a promise not to do something in future. Now, there are other types of consideration when you think about every type of contract. Shares in a company, providing work for your employer. These are all good consideration. Why am I using that word good? It just means valid, a type of consideration that the common law courts will recognise. Yes, that is consideration, good consideration. Money is obvious, so I sell you this little piece of fruit for £1. Your consideration is the money, and my consideration is the goods. We've exchanged, so therefore it's contractual. We have a legally binding agreement. A promise to do something in future. Give me £10 and I will look after your baby on Saturday for 2 hours. If I don't turn up on Saturday, I'm in breach of contract. We have formed a contract. You promised money and I promised to do something in the future. You're right and I'm wrong, and a court will say that was a contract. How about a promise not to do something in the future? That is properly called forbearance. And if you look at case law, our judges have decided in certain circumstances that a promise not to do something that you probably really want to do in the future, that counts as good consideration under a contract. Grammar, sorry. Consideration is an uncountable noun in English. So the first thing you cannot do with an English uncountable noun is to put a directly before it. You can't say a consideration. The same way that you can't say an insurance or an evidence. They're other uncountable nouns that are very important to lawyers, so you can't put a or an in front of it. Conclusion, it's always just consideration. It's never a consideration. It's also incorrect to add an S to make it plural. So, for example, if you buy my hotel, let's imagine in the posh part of London, we'll say Mayfair. Why not? We're dreaming. And you want to buy my hotel, okay? And you pay me, and I agree. Some of it is money. I'd also like, number two, some shares in your very successful new tech company. And why not a free holiday on your private island? Those three things are your consideration, no S. So never make it plural and never put a directly in front of it, and you'll be fine. How do common law lawyers know what is good consideration under a contract? Now, you know that we have no civil code. I think you probably look in your code and then in case law for clarification, but we have no code. So what we have to do is look at precedent cases where judges were asked about a type of possible consideration for the very first time, and that judge, when asked probably 200 years ago, said, yes, that is good consideration, or no, that is definitely not. That's how we know what's acceptable and what's not acceptable to create a legally binding contract. It's case law. Congratulations, you can now use the word consideration like a legal professional. To practice this word and more for free, download that PDF, do your homework from Cambridge. The answer key is there for you. You can learn a lot of new words, and the link is in the description below. Bye for now. See you next time.